Yes, morning, sir. Lordship, item 14, I need some time, 2 weeks' time.
Who is the other side?
Other side,
Copy for respondent number 2. Lordship.
2 weeks' time, your Lordship, I need it. Okay. Yes, 14 is yes, sir. Yes, at the prayer. There's any private respondent in this matter?
I'm the private respondent. Lordship.
And then state? State is there. You're there. You have no objections?
No.
Yes. Yes, just as the request made on behalf of the petitioner. This matter for 2 weeks. Yes.
May I please, Your Lordship, I beg to mention item number 6 and 7. Both are connected matters.
Yes.
I'm praying for 3 weeks' time, Your Lordship.
6 and 7. The request to the petitioner, list after 3 weeks. Yes.
Much obliged, Your Lordship.
Please, Lordship.
Yes.
Please, Lordship. I beg to mention item number 12, Your Lordship. I'm here, I'm the for the petitioner, Lordship. Maybe I pray maybe come up after 1 week, my lord, or 1 or 2 weeks. It's a for private respondent.
I'm for the private.
Supporting his case?
Yes.
Who is the state?
Government actually I have informed, but she's in other court.
Miss Anjishila.
In DC.
You have informed?
Yes, I have informed to her junior.
And then any interim order, anything, any kind?
Nothing.
What is the matter about?
Actually, this is actually compromise, Lordship. What happened? The main accused.
What is the crime involved? Just what is
The
the
crime involved is just alleged of kidnapping, Lordship.
Okay, then state. I don't think there will be any somebody.
Yes, I have informed to.
Just also this also sir. At the request to the petitioner, list after 2 weeks. Yes.
Lordship. Much nice, Lordship.
May it please, Your Lordship. Your Lordship, I beg to mention item number 3. Your Lordship, we pray that this matter may come up after 2 weeks, Your Lordship.
Why?
Your Lordship, Dr. N. Muzika has some personal difficulty to appear today, Your Lordship.
We are seeking time in peaceful every time 1 week, then.
Your Lordship, there will be a joint request of parties.
When?
Your Lordship, after 2 weeks.
At the request made on behalf of Dr. N. Muzika, known as DSJ, this is matter after 2 weeks. Yes.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 8 and 9, Your Lordship. It's a joint request from both the parties, Your Lordship.
Yes, Lordship. After 3 weeks, Lordship. Get in time also. At the request made on the respondents. At the request made on behalf of Dr. N. Muzika. Okay, after 2 weeks. 8, 9, both. Yes. Okay.
Much obliged, Lordship. Your Lordship, I beg to mention item number 13.
13, yes.
Your Lordship, I'm seeking 3 weeks' time.
This is a matrimonial dispute.
Yes, madam.
No chance of settlement.
No, sir.
You have tried it.
Sir?
Have you tried for a
Yes,
settlement?
Your Lordship.
Was it sent to a mediation center?
No.
Who will send it to mediation center? Anyway, today you are asking for 2 weeks' time.
3 weeks' time, Your Lordship.
No objection. Yes, 30. Yes, the request of there is only one respondent.
Yes, Your Lordship.
No request to respond. List of 3 weeks. Yes.
Obliged, Your Lordship.
May it please, Your Lordship.
Only 3 weeks at the request of the respondent. Yes.
Lordship, I beg to mention item number 10, Lordship.
Yes.
I pray for further 3 weeks' time, Lordship.
What is the matter about Mr. Dev?
This matter about, Lordship, quashing of the POXO cases, Lordship. POXO case, Lordship.
The POXO case.
Lordship.
You are seeking quashing.
Yes. Lordship.
On what ground?
On the ground, Lordship, the victim who is at present my wife, we are living
Same issue is
together.
pending.
Same issue.
Yes. This also after 3 weeks at the request of the petition.
Lordship, 3 weeks, Lordship.
3 weeks, definitely. Because the issue is pending before a division bench. So you
Issue
have
is
to wait.
pending.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 11.
11?
Number 11, yes, Your Lordship. Your
You're
Lordship,
appearing for?
for the petitioner, Your
Yes.
Lordship. Yes. Your Lordship, this matter has been disposed of before the Principal Magistrate of GJB under Section 258 of CRPC. The proceeding against the petitioner number 1 has been stopped.
Well, we could not follow. What is the matter about? What is what for this criminal division is?
It's a POXO matter, Your
Yes.
Lordship.
And then what happened? It's a
They
POXO
are
matter.
husband
And the petitioner
and,
is the accused.
yes, Your Lordship.
Yes.
And the petitioner number 1 is the accused and the petitioner number 2 is the victim. They are staying together as husband and wife, Your Lordship, and
Yes, yes.
they have a child also. And the case was disposed of on 2nd of this month.
The trial.
Yes.
And it has resulted in acquittal or
Stop order proceeding, Your Lordship, under Section 258 CRPC.
what is that?
Lordship, in fact, proceeding were pending before the JJV, Your Lordship. So against
Juvenile
against that they have come, Your Lordship. So it appears, Your Lordship, from the website, the lower court, Your Lordship, that the matter has been disposed of on 2/8/2024.
Yes, then
What is the nature of the order that
Your Lordship, I have already applied the order, but I have to look at and this is required.
What do you want to do?
I will submit, Your Lordship. Kindly give me 2 weeks time to submit that.
we'll give it 2 weeks. Yes, Mr. Sulai.
Lordship, yes,
This also 2 years at the request of the yes.
obliged,
Yeah, please, Lordship, I beg to mention item number 5, Lordship.
Item
As
number
my
5.
senior H. Nakral is out of station, Lordship.
Yes.
My senior H. Nakral is out of station.
Yes, Mr. What? How long? When do you want?
2 weeks, Lordship.
2 weeks at the request of the number 5. Yes.
Supplementary cause list. Item number 1.
Yes.
May I please, Your Lordship? Your Lordship, in this matter, I humbly pray to kindly grant us 2 weeks time, Your Lordship, because in this matter, there is some confusion, Your Lordship, because last night we were informed that there is some subsequent development, Your Lordship, in the criminal miscase which we have filed. So we need to obtain instruction, Your Lordship, before we proceed with the matter, Your Lordship.
In fact, the revision or the criminal petition or revision won't lie, Your Lordship, because against the show cause notice, Your Lordship.
Against no, suppose not.
Show cause, Your Lordship, what happened? He's the petitioner, he's the owner of the truck that has been released on Zima, Your Lordship, because he was found to be loading carrying illegal coal, Your Lordship. Coal has been seized, Your Lordship. There is an order of the NGT that before releasing 50% of the value of the property, say a vehicle has to be deposited, Your Lordship. That was not done, Your Lordship. So in view of that, Your Lordship, learned court below, Your Lordship, issued a show cause notice.
NGT order will bind the court here.
Lordship, because there is a Lordship, because this is under the Mine and Minerals Development Act 1957, Lordship. Section 21 of the Act will be applicable, Your Lordship. There was a case registered also against the petitioner.
NGT is an authority under the Mines and Mineral Act.
Yeah, because it's all environment, Your Lordship.
But that is okay, but then see the very establishment, whether it's statutory or not, that is the main thing. Until and unless there is statutory.
There is an order, Your Lordship. There is an order, whether that has to be.
How far order of NGT, especially with regard to the procedures to be followed by a criminal court.
That is, there is no quarrel with that, Your Lordship. There is no quarrel with that. The only thing is that because it was seized during the course of police during the criminal investigation, the truck was seized, the coal also was seized, Your Lordship. the vehicle was released in semi, Your Lordship, into the custody of the petitioner, Your Lordship.
Your Lordship, the petitioner here wasn't aware about the call, Your Lordship.
Whether
He
he's
was-
aware or not, Your Lordship,
Legal merits, let him.
proceeding under Section 21 of the Act of 1957 will be there, Your Lordship. Confiscation is liable to be confiscated, Your Lordship.
Your Lordship,
That
if you
proceeding
can-
is there, Your Lordship, before the trial court.
Your Lordship, if you kindly grant us 2 weeks' time, Your Lordship, we'll obtain the instruction, Your Lordship.
List of activities, the request of the petitioner.
Apply, Your Lordship.
Item number 2. 4.
Lordship, this is a matter where Honorable Chief Justice had passed an order. Yes. So listed with Chief Justice's order. So that order is at 4th March 2023. 24, sorry. And 4th March. So Lordship, the relevant part would be the next page. 4th March. Yes. The relevant part, Lordship, would be the next page, yes. The last paragraph. So just to refresh what happened in the last date. Yes. So this was the observation, Your Lordship. The case of the petitioner. Lordship has got it. Yes. Please go ahead. The case of the petitioner is that even though the petitioner has been placed under suspension, he has not been paid subsistence allowance, which fact has been admitted by respondent. Non-paying of subsistence allowance vitiates the entire domestic inquiry, as has been laid down by apex court in case of so and so. This is the relevant part, Your Lordship. Since the writ petitioner has attained the age of superannuation as early as in 2012 and 12 years has been gone by now, the question of putting him back in service does not arise at all, and remanding the matter is going to give rise to one more round of litigation. Hence, in order to give quietus to the matter, this court has suggested, I am emphasizing on the word suggested, the counsel appearing for the respondent that the employee may be paid pension and gratuity alone for the actual service rendered by him. It is also suggested, again emphasis, Your Lordship, to the counsel for the petitioner that the employee could not insist on payment of subsistence allowance and other benefits in order to put an end to the litigation. It is stated before the bar that during pendency of the proceeding, suspension was revoked on 23/5/2003. The counsel for respondent sought time to get instruction and the report the same on the next date of hearing, posed the matter on 20 March 2024. So, Lordship, finally, this matter was, after this order was passed, this matter was listed, and two occasions, Your Lordship, I had sought for time. Because the instruction that I got from my department was, since he was not a regular employee, so maybe the second part, the suggestion could not be, we can't comply with the suggestion because it was the instruction received that he was not a regular employee, and but Your Lordship, where the matter stopped was, Lordship had asked me, Mr. Khan, how do you overcome the 1983 judgment? Because if subsistence allowance was not paid, and in 1983 the Honorable Court had held, and everything gets vitiated. And in the last occasion, Lordship had asked me that what would be the consequences now? And there was two very important questions asked, that whether the judgment has been overruled, or if there is any other judgment that gives some clarity to this, because that is the only issue. That is, the one thing is that 1983 says that if there is no payment of subsistence allowances. Yes. Now, subsistence allowances, definitely, if a person is suspended, they are probably paid monthly subsistence allowance. Lordship is correct. It has to be paid on monthly basis, isn't it? Now, non-payment means what? Say supposing if there is a delay in payment, or say supposing if a person is suspended, he remains under suspension for a period of 3 months, within which the departmental proceeding initiated against him is completed. Lordship is correct. But then what happens in 3 months? He was not paid. Yes. Would it vitiate the trial? Even for a short span. Yes. Now, we do not know what exactly this 1983. So Lordship, we stuck up with that. But then once it is observed here in this order, yes, that it vitiates. Madam, how long you remain under suspension? Your suspension was revoked in 2003. And when the incident took place?
Incident in 99.
99. So for about 4 years. No, Your Lordship, very important issue is this, because this has been observed by the court and a judgment has been relied. Now, what has happened, Your Lordship? A further clarity has been given on this aspect. Before I read the para 7 of the judgment, Lordship, allow me to just give a bit of factual clarity. Yes. Because without factual clarity, then maybe we'll be getting into the legal jargons. Now, what has fallen from Your Lordship was very important. And I am grateful, Lordship, you have clarified me and made me in a better position to clarify the fact.
that from the day of commission, suspicion and completion of trial. So that this stage is very crucial also. And what has fallen from your lordship, that what happened if the suspension allowance is not paid,
Then you can sit down.
and subsequently it has been paid by magistrate. But the crucial time is from the date of suspension or from the date of inquiry till the dismissal order. That is very, very crucial to make whether then the second question has to be answered. That period, first thing, lordship, I want to clarify this on factual situation. That period is very crucial. Then the second issue is, lordship, because of non-payment of subsistence allowance, for some reasons he could not participate or he was prejudiced, then the issue of vitiation will come. Lordship, I am repeating again, if for some reason prejudice has been caused by non-payment, then the issue of non-prejudice. But if prejudice has not been caused and the delinquent or the erring official has participated, then the issue of
This 83 decision,
yes,
is it relatable to the causing of any prejudice? Like
lordship, that thing has been clarified in 2004. I'm coming to para 7 now, lordship. 83 says about vitiation, not payment. 83 judgment talks about non-payment of substance allowance will vitiate the entire proceeding.
So non-payment means something what? Let's see, non-payment.
Exactly.
That is, you see, non-payment means like it is a total non-payment
or part.
It's a partial non-payment.
Lordship, I'm absolutely grateful. Those two positions are very valid. But 2024 Lordship has clarified further by saying it is clarified saying there should be an element of prejudice. So if the
because of non-payment of
yes, so Lordship will just come to it. And
okay, this 83 decision was discussed here.
83 it was discussed here, Lordship, a bit, but then if para 7 left referred, yes. But Lordship, para 7, we'll just go slowly, Lordship, to clarify the fact.
Yes, para 7.
Please. We are relying on the previous judgment. I was supposed to ask query on it. I'm into it. Just find out.
Yes, what the para 7 says?
From the judgments of the High Court in the writ petition, it appears that there is no reference to the alleged infirmity on account of substance allowance having not been paid. Alleged infirmity is very important, Your Lordship.
What is that infirmity?
Lordship?
From the original
No, I'll come to it, Your Lordship. I'm saying that what the Honorable High Court is observing in the right now, it is observing the judgment of the High Court. There was no specific finding recorded for the question of bias as alleged presently. We find that there was total lack of cooperation from the appellant, as the factual background highlighted above would go to show. Ample opportunity was granted to the appellant to place his case. He did not choose to do so. It was only a person who is ready and willing to avail the opportunity given who can make a grievance about denial of opportunity, and not a person like appellant who, despite repeated opportunities given and indulgence shown, exhibited defiance and total indifference of extending cooperation. The relevant part starts from here now, Lordship. Therefore, on that score, the appellant cannot have any grievance so far as the effect of not paying of the substance allowance is concerned. Before the authorities, no stand was taken that because of non-payment, this is relevant, Your Lordship.
Yes.
Because of non-payment of substance allowance, he was not in the position to participate in the proceedings, or that any other prejudice in effectively defending the proceeding was caused to him. The appellant could not plead or substantiate also that non-payment was either deliberate or to spite him and not due to his own fault. It is ultimately a question of prejudice. Unless the prejudice is shown and established, mere non-payment, this is relevant, Your Lordship, mere non-payment of substance allowance cannot ipso facto be a ground to vitiate the proceedings in every case. It has to be specifically pleaded and established as to in what way the affected employee is handicapped because of non-receipt of substance allowance. Unless that is done, it cannot be held an absolute proposal in law that non-payment of substance allowance amounts to denial of opportunity and vitiates departmental proceedings.
1983 decision has not been referred to in this decision. Is it? I don't.
So sorry, I'm just asking Mr. Akin to just have a look on that.
I don't think it is. It is there. There is no reference of the decision in this
It doesn't look like.
in this case.
No reference is made. Your Lordship is
Mr.
correct.
Kappa, you have seen it.
No.
We have seen this.
No,
Let's go to this 83
order is
decision.
fine, my lord. The order which my learned senior is reading on it, we don't have a copy.
No, that is not order. This is a
No,
decision.
no,
of the-
this 83, my lord, 83 order, my lord, I'm not sure whether it's been overruled or not.
No,
Whether
no, we're not talking about overruled.
There is no question of specifically overruling that.
Yes,
See,
yes.
But then Mr. Khan here has
latest
produced a
order.
decision
Yes.
according to 2004, wherein the proposition laid down therein
It's
seems to be
different from
totally opposite to what
different from what.
Yes.
But this has been.
Now,
But
in 2004 decision does not show that that 83 decision was.
Absolutely.
referred.
Then what happens? What is the law?
Well,
83 decision is by two judges.
Both are two judges.
Then what would be the law? Tell us.
Law.
You know it, and if you know that the proposition is against you, you would say you.
Lordship has asked me a very important legal question, Your Lordship. I'll try my best to clarify this. At least I'll try my best. Lordship, both the judgments are correct. Only difference is this: one lays down 1983, Lordship. 1983 judgment is, it says non-payment of substance will vitiate.
Itself will be shared. That is good enough.
That itself is good enough, and it was dealing with a criminal case on a criminal appeal. Factual situation is that, Your Lordship. Just to assess the court, I've gone through the judgment. It was basically after conviction whether in a case of appeal whether it violates Article 311. And then the issue of non-subsistence allowance.
You are trying to distinguish these decisions. You see, normally the question which the court has asked.
No, I'm coming to that, Your Lordship. I'm just coming to that. First, allow me, Your Lordship, just to clarify that part. But the major, the legal issues remain same. I'm not denying it. The issue is this: non-payment of substance allowance will vitiate the departmental proceedings. Lordship. So
That is a correct proposition of.
that is a correct position.
In
of
spite
law.
of the 2004 decision.
Now, 2004 Lordship, 2004 decision has only clarified the proposition of law. Factually, it could be different. It is only clarified. It says there has to be a pleading, and if I may read,
So
Your
it
Lordship,
is, you want to say that this is not directly in conflict. The
it
proposition.
is not in conflict. It is. Lordship,
That's further clarification.
Your Lordship, if I may say, they have expounded clarity to the legal position. It has not. So, for vitiation is concerned, both the judgments are same. This has further clarified that the element of prejudice during that trial or during the inquiry, it has to plead.
But then how do you say when there is nothing to show that 83 decision was under consideration before the apex court in 2004?
Lordship, as I submitted, if it had overruled or some different proposition of law.
No, we can say it that way that 83 decision was not at all placed before this court. So there is no opportunity
Lordship is
for the
correct.
apex court in 2004 to
Lordship.
clarify the judgment of 19.
Absolutely correct. But the Lordship will agree there's a fine distinction. So far proposition of law is concerned, both 2004 and 83 is on the same legal principle of vitiation.
And you do not see any conflict in those
No
two
conflict.
decisions?
Absolutely, Lordship. Yes, I am
Whether
grateful, Your Lordship. I'm
one-
grateful for
one
clarifying that.
supplement other.
Exactly. Both are supplementing each other.
We know, Mr. Khan, you will definitely use your ability to make this kind of things. Now, say supposing,
Yes, Lordship, please.
even thereafter also,
Yes.
if we find that there remains slight contradiction in the fact that 83 is only confined to the non-payment of subsistence allowance. And it says that the very fact that non-payment of subsistence allowance would be issued.
Lordship.
Now, that basically gets furthered by this 2004 decision.
Yes.
Now, 2004 decision, that way, it's slightly different than what has been stated in 1983.
Yes.
And there apparently seems to be a bit conflict so far as that thing is concerned. You see, here it's a case of mere, we take it this is a mere non-payment of subsistence allowance,
Yes.
which you have admitted in your earlier judgment record.
No, absolutely.
When 83 said this is good enough.
This is good enough.
Now, if you say that the 83 decisions or proposition of law is further stands clarified with the 2004,
2004.
it seems something, rather we see there is a difference. Because you see the 83 decision has not taken into consideration a question of prejudice, whereas 2004 has said it.
That part, Your Lordship,
So that means that the very proposition which is 83 has passed stands diluted by 2004.
Lordship is correct.
And there apparently seems to be difference between two propositions.
Lordship is correct.
One says up to certain things it is enough, the other says no, it has to be pardoned by other courts.
Absolutely. Lordship,
Now, in case of conflict between the proposition of law promulgated by two bench of equal strength, then what is the law? Yes, Mr. Thapa.
Something very tricky, my lord. In my humble submission, my lord, 83,
the law says the decision which comes first.
Yes,
Proposition.
83, my lord, it's holding the field for quite a long
Definitely,
period.
that is why. See, that is why exactly this question was put to Mr. Khan.
But Lordship,
Even if you see there is a conflict, this 2004 will not overrule the.
but Lordship, can I clarify with a different set of law? Lordship is aware of Ramzan Ali.
Yes.
Ramzan Ali was the
I'm not
first.
very aware. Okay, hard about.
But I'll just give
this
a
court
background.
is not at a lawyer.
Yeah, I'll just give you an example. Lordship. Ramzan Ali case was the first landmark case which says non-supply of inquiry report. It's exactly the proposition of law is directly connected with this case. It says non-supply of inquiry report will vitiate the entire proceeding. Before that, there was a grey area. And Your Lordship, from Ramzan Ali, we go 5 years ahead. Then we have UCL versus State of Karnataka.
Question of prejudice.
Absolutely correct, Lordship. And UCL said clearly that
UCL has taken into consideration the proposition of Ramzan Ali.
the same thing.
2004 has not taken.
Not
into
taken,
consideration.
Lordship. That's the only difference. Yes, I agree with you, Lordship. Lordship, I agree with that part. But assuming it has not taken the proposition, UCL was an improvisation of Ramzan Ali, and he said no, the element of prejudice has to come. Now, allow me to just improvise my argument, Lordship. Here the issue is this: both the judgment agrees. It is not an improvisation on 1983. But both the judgment agrees that vitiation part is common. The only thing is this: vitiation per se ipso facto will not be applicable if non-subsistence allowance is not paid. There has to be other consideration. Now, Lordship, if you bring this proposition of law into this factual situation, in this situation, right from the time when he was suspended, the inquiry proceedings till suspension was revoked, till DP. There is no whisper, no argument, nothing.
Then what will happen to the order passed in this matter, whereby the court had made a suggestion to give weightage to the entire dispute here.
Lordship.
Now, before this court went ahead to put a suggestion to the state, it has said, it has categorically held that on the basis of the Tapas Court judgment, the proceeding gets vitiated. Will it not that this order will bind here?
No, Lordship.
Because it is passed in the same proceedings.
Lordship, now we have a very tricky situation. Had the order been passed by a division bench, and this Lordship was hearing this matter in a single bench, then it would have a binding effect. In the same proceedings, before one particular judge, and certain observation has been made, and the coordinate bench of the same Honorable High Court is taking up the matter. Now, the 2004 judgment never had an occasion to present itself before the court to clarify on the issue. And this judgment also was neither relied by petitioner nor by the respondent. So a proposition of law emerged, and there was no occasion for 2004 to
Will
be.
it not be that, say, like if you take a different view now, on the basis of your submission,
Lordship.
on the basis of proposition of law from in 2004,
At least,
it is not made that it will not amount to taking of a different view
no,
than
Lordship.
what had been taken
No, Lordship,
in
Lordship,
this
for-
very proceeding.
Lordship, no, because coordinate bench is dealing with the matter, and at the best, Lordship can say that the observation made herein in 83, Lordship will not disagree with 83, neither with the finding. Lordship can say that part could at the best be per inquiry. In so far as the factual matrix is concerned, in light of 2004, if the court wants to venture out, Your Lordship.
So total submission is total aimed at, you see, defending the state.
At the I'm just giving a suggestion. Lordship may overrule my submission.
It's not a neutral expression of opinion so far as the law is concerned.
Lordship, because Lordship, my situation would have been very easy had I appeared before, like if the matters before the division bench.
It goes in a lighter mode.
Lordship, same here, Lordship. Same here. Lordship, kindly just appreciate the difficulty. Sometimes we have in navigating.
See, Mr. Khan, there are certain propositions we don't think that there will be a dispute between the court or you. So
Absolutely, not
decision of a coordinate bench will bind the subsequent bench. That is a proposition of law. We cannot define these things. Now say we do not know whether any finding given at the interlocutory stage would bind the court.
Lordship has raised this is a very important.
That is one aspect.
That is one aspect of the
But
matter.
then otherwise, if we treat that order of that order by which suggestion was made, if we say that there is a finding, clear-cut finding made with regard to the fate or the with regard to the proceedings which was initiated, because it has in clear terms said that as stands vitiated because of non-payment of subsistence allowance, state has agreed. So because of the proposition of law and so
yes,
vitiates.
yes.
So and then it further goes saying that since the petitioner has attained the age of superannuation 12 years back, so there is no question of giving back in service.
Correct.
Then thereafter the suggestion comes.
There,
Now
yes.
that
Suggestion
remains,
part is
so
separate
the first
part.
part remains
First part, yes.
categorical finding.
Lordship,
Now,
Lordship is
right
correct.
now,
Lordship is
just let us finish.
sorry.
If we take a separate view, is it not, or different view, is it not required that should go before division bench? Because we cannot override.
My first submission, Your Lordship, had that observation of the Honorable Supreme Court and that particular observation of the first part culminated into a judgment.
Not a final.
No, Lordship, not a judgment. Then if I would have filed a review, then the situation would be different. Now, so Lordship, once we eliminate this first proposition, then we have a second proposition to answer. The first part of the observation did not culminate into a judgment. It remained in the stage of, I don't know, for the lack
Consideration. It was rather
of consideration. I don't know, Your Lordship, for the lack of proper use of legal word, I can at the best say interlocutory or
We can
consideration.
say that is a prima facie view, not a final view.
Absolutely. I'm grateful, Your Lordship. So that's why I said due to paucity of lack of exact appropriate word, because normally we have in a missed case in a trial court, but in a high court we don't have
That is
a
what we see, interim order or the interlocutory order passed in a proceeding.
Absolutely.
These are on the basis of the
Prima facie.
Prima facie. Yes.
So maybe what is
We can never be equated with final.
absolutely. Had it been final ownership, then I would have no question to forward this argument. But if it's prima facie, and one important Supreme Court judgment which does not contradict, which is coordinate bench, but which has further clarified the proposition of law and facts on the element of prejudice. So we have a situation whether the court on being brought to this judgment, which was not there at the stage of prima facie. 2004 judgment had never an occasion to present itself at the stage of prima facie, but it found expression in the final stage, as I am doing right now. Will the court first take cognizance and distinguish the fact? Number one. Number two, it's not a review application, and it is a stage of final hearing of the same matter, and this honorable court which is hearing it is also the same coordinate bench, and it has not an occasion to handle a review matter. Rather, same cause of action, same petition. Only difference is this: it is in the stage of final hearing.
Mr. Thapa, you are ready for final disposal of the matter?
But I may be given some time to read
No,
this judgment which my...
which needs
Yes.
to be clarified. Two aspects, you see, whatever it is, the order passed by which the suggestion was made, it seems that this order is not working anymore. In view of the state said that your service was not permanent, not regular. So there is no question of extending that benefit to you. So what remains is that we have to decide this matter.
Absolutely.
Now, the conflict between that 83 decision and 2004 decision. Now that is what the main thing is. Now just make a research on those.
I'll do the in fact, that particular judgment, my lord, I have not been supplied with a copy. I'll just go through
You
that
just take the
judgment. my lord.
citation. You will not supply by citation.
Yes, I'll take the citation, my lord.
Just take the citation from.
Yeah, yeah.
My lord may have this matter next week. I'll just go through
We'll
this
have it
judgment. We'll
after
try
2
and
weeks. We'll not next
yes.
week. We'll have it after 2 weeks so that you have enough time also.
Just
And see through, because that is of course the legal aspect of the matter.
Correct. Or else, my lord, we have to
Otherwise
go
you have
into
to go to the merits of the
merits only, my lord.
Mr. Khan, we will record that your submission that on instruction that the suggestion is not acceptable to you.
Lordship.
You can say that. Or you want to explore some more thing.
No,
We
Lordship, keep it open.
That is better. You see, if you can,
absolutely,
see,
Lordship
one
wants
thing is that
some.
you can give weightage to the matter, that is very good. Why don't you give some benefits? It is not that
Lordship, anything within the permissible limit, the state is always willing. And for a forum in Lordship will kindly appreciate.
Sometimes you see,
Yes.
what is permissible and what is not permissible also remains in your hand. So,
But Your Lordship, when it comes to ad hoc, Your Lordship, when it comes to ad
the
hoc,
limit of permissibility is always flexible in the hand of the government.
but Lordship will kindly appreciate one thing. When it comes to ad hoc or temporary employee, Lordship, if thing has to go through cabinet in the absence of any rule, because it opens up the floodgate. If government takes a decision without rules, without amending the rules or without decision, that is the only problem when you're dealing with such cases. So that's why, Lordship, in most cases we rely, finally the government also relies on the wisdom of this honorable court to at least mold some relief. It's not for a moment that we don't want to give, but we have some restraints when it comes to that.
So what shall we do? We'll simply adjourn it for 2 weeks.
Lordship, let him go through it also. If he
So we'll
fails.
just say on the joint prayer of the parties. We're not saying, because and you also have your complete set of instructions there. That is better by that time. But then plus see please see if anything can be done. See, person under litigation from 2015 and then
Lordship, from
served
2015.
you for many years.
Government
get
can
some benefit.
consider the hardship that is undergone, my lord. So
That is what you see, and then the incident which had happened, though he is liable for that, maybe you see, like if it is the charge, whatever is is correct. But then the fact remains that he is not one man. He was not the one man responsible for protecting the entire jail. This is a case where we have not, you say, like penalized any other person, isn't it? He's the only person, only victim of the entire incident.
That part, Lordship, yes.
That is also one thing
that
that
is
is bear in mind.
as a matter of fact,
For the purpose of creation sympathy in your mind, for the purpose of creation of sympathy.
Lordship, when it comes to sympathy, the other aspect of this matter is this, since 2015, he and me opposed the court. He got his interim stay from this court regarding not vacating the quarter. In spite of the fact he's been terminated.
No, he's still in court.
He's still.
No. Quarter, I think, is left.
No, but he has an interim order by this court. We don't know what has happened. He's not informed the court.
Giving on rent to somebody else.
No,
He's
no,
giving
my
on
lord,
rent
no.
to somebody
In
else.
fact, this gentleman, my lord, he seems to have shifted already to his native
And what
village.
happened to the quarter?
Quarter, I think, is vacated, my lord, if I'm not wrong.
he's
He
not-
must have vacated by now.
Has it been handed over officially? Or you
I
have given it
seen
on rent to
instruction
somebody
on that,
else?
my lord. No
Clear
no
the
question
dues
of
the subsistence allowance.
subletting it to any other individual.
Recover the amount of the subsistence allowance. No such plan in your mind. Okay, at the joint case of the parties list of documents.
But Lordship, this issue is very interesting. I hope Lordship at least give a quietus to this issue that has come up.
No, and thanks for giving that 2004 judgment. Otherwise, this court was of the view that 83 is.
No, 83 Lordship, only on 83 then Lordship is correct. We didn't have hardly anything to reply.
What weapon Mr. Thapa brings.